Hello everyone, I hope that you are all doing well. This is me, Sayyid Shujatullah. To all my dear students out there, a very happy Eid. So Eid Mubarak to everyone. I hope that you are enjoying this Eid peacefully and joyfully. So please study hard because examination has been postponed for 4 months. That's not a small time. I hope that any of you who are not, who have been thinking about that they cannot do this time. Now with the 6 months period, if you are still not able to be confident, then it is very difficult. Then it is very difficult. So please try to get up. Try to on this is any auspicious day. So please start from today and get what you dreamt from a year or kind of year you have been in this field. Please don't lose hope. There's lot of time is there. 180 days. We are not joke. So study hard, be consistent, watch all my videos, and please be in contact if you're having any kind of confusion with regard to the syllabus. If you wanted to ask me for guidance and mentoring, I'm always there to help you out. My Telegram link will be there in the description. So please do subscribe to my channel and also join my Telegram group so that I will be happy to help you. Okay, because of this much I have told you, I have not put any advertisement. Okay, directly I am going to the what I say is to the discussion itself. So MCQs on Supreme Court, those who are watching me for the very first time, I have already discussed 1 to 5 MCQs on Supreme Court in my previous video. Please watch it. Okay, then this is 5 to 10. This is 5 to 10. Every chapter, 25 MCQs of high quality standard I will discuss along with analysis, interlinking of things, so on and so forth. Okay, so by the by the time we write prelims, you will be done with economy so perfectly, polity so perfectly. I hope I'll also start environment, okay, or disaster management in later stages. Fine. See, these questions already we have done. Now let us see the sixth one. Consider the following statements. So it's all about NJAC. Okay, National Judicial Appointment Commission. So first of all, before doing this MCQ, let us see some static data. It is a static data because it is an act which has been passed. Again, this act has been struck down by the Supreme Court, and Supreme Court said that we don't need this kind of act for the appointment of judges. Okay, appointment of judges, they don't need this act. Whatever the previous system was there, that is all fine with us, and we will follow the same system for the appointment of Chief Justice of India and also Supreme Court of other judges of Supreme Court. That is what Supreme Court has told. That is why it is a static concept. It is not a modified one. It cannot be modified. It has already been struck down. It was declared unconstitutional by the Supreme Court. But still, you should know about this because it has been in the news many times. Remember one point, my dear students. The power to appoint Chief Justice of India and other judges of Supreme Court is given to President by the Constitution. Is given to whom? Is given to President by the Constitution. So let us come to CGI. According to the Constitution, Chief Justice of India shall be appointed by the President. Very right. But he should do so by consulting, by talking to the judges of Supreme Court or High Court, judges as he thinks necessary, as he deems necessary. Means यहाँ पे President of India CGI को appoint whenever he is doing, he has to consult High Courts, any of the High Courts judges or Supreme Court judges. Okay, now you can understand that this is a very vague provision. This is a very vague provision. It may happen, as you all know, Article 73 or 74 talks about that PM, the President has to act. The President has to act on the advice of what? PM and Council of Ministers, right or wrong? Yes, President has to act on the advice of PM and Council of Ministers. This is very right. If President has to consult on his own the judges of High Court and Supreme Court, it may happen that the PM and Council of Minister may recommend him, so consult, sir, you please consult the Supreme Court Judge A, Supreme Court Judge B, High Court Judge C, High Court Judge D. Please consult these people only. And let us appoint a CGI who follows our political ideology, who is more inclined towards our values and culture, like that. It may happen or not. So President of India decision can be easily influenced by PM and Council of Minister. Why? Because he has to act, President has to act according to the aid and advice of PM and Council of Minister. Okay, so this provision is very very vague. Okay, so why? Because PM and Council of Minister may recommend President that you please consult so and so judges of Supreme Court and High Court. Okay, so that their person, okay, their ideological person may come to may become Chief Justice of India. With that, what happened? Whatever the laws that they will make, that anyhow will be passed, right? So to avoid this situation, a 9 bench judgment was given. Means the bench is nothing but 9 judges took up the same matter. Why? To look into this vague provision. Okay, there should be a proper method of election of Chief Justice of India or not. Yes, this is a vague provision. So in order to bring certainty, a proper methodology to appoint Chief Justice of India, many petitions were put, and a 9 bench judgment came into being. Okay, and this bench have declared that you don't need to president don't need to consult any Supreme Court or High Court judges for the appointment of Chief Justice of India. He can directly appoint the senior most judge of Supreme Court directly as Chief Justice of India. तो अभी तो जरूरत ही नहीं है. नाउ इट इज नॉट एट ऑल रिक्वायर्ड. जिसकी उम्र ज्यादा है, जो सबसे सीनियर है, उनको आप डायरेक्टली चीफ जस्टिस ऑफ इंडिया बना दो. बात ही खत्म. Right? Supreme Court has at present 30 judges are there. It is now increased to 33 judges, including Chief Justice of India. Okay, means 34. They are 34. So ये 33 judges में से, okay, जिसकी उम्र, whose age is more, he will become what? Chief Justice of India. After he goes, the next oldest Supreme Court judge will become Chief Justice of India. So very simple, very proper methodology has been given by the 9 bench judgment of Supreme Court judges. So now, gone case, this particular matter of appointing the Chief Justice of India is totally settled by the provision of appointing the senior most judge of Supreme Court as Chief Justice of India directly by the President. So Chief Justice of India matter is over. Then what about how the other judges of Supreme Court have to be appointed? This is a question now. Okay. So before how the Supreme Court judges were appointed, and after this National Judicial Appointment Commission came into being, what is a selection process of this? Okay, what is the selection process followed by this NJAC? What is the previous selection process followed by the judiciary in appointing the Supreme Court judges? Let us see. The total NJAC bill is related to what? Issue of appointment of judges. Current method, means still running method, is there is no executive involvement in the recommendation of judges for appointment. PM and Council of Minister. You know that Union Executive you might have learned in your examination in your Polity Lakshmikant or not. Union Executive. PM, Council of Minister, and you are having President, okay, Attorney General, okay, all this makes what? Union Executive. So now the current method is this Union Executive is not involved in recommendation of judges for appointment. Gone case. But NJAC provide these people's interference also. NJAC provides that PM and Council of Minister and executives to be a part of appointment of selection of judges of Supreme Court. Judiciary, here only judiciary is there, okay, but no executive. Here judiciary plus executive is also there. So judicial and executive involvement, executive participation is envisaged under the new method, whereas current method does not involve any of their interferences. Next one. Here the appointment of judges, Supreme Court judges, were independently carried, okay, by the judiciary without executive influence. I have told you. Here the appointment of Supreme Court judges will be done on the decisions of both judiciary and executive members appointed to this particular commission. Okay, so it means they are dependent on them. So interdependence is envisaged, okay, with respect to appointment of judges, okay, under this method. under this method. It is a multi-member. Yes, it is a multi-member. The system of selection of appointment of judges of Supreme Court, the group of member who does all of this selection process, we call that system as collegium system. This system is also called as collegium. Not at all, no issue at all here also. In NJAC, as we are having PM and Council of Minister Union Executive interference is there, it may happen that ruling party may have their candidate appointed as CGA. Okay, it may happen. Here, no possibility at all. Why not possibility? Here, executive does not involve at all in the appointment of Supreme Court judges. I guess you got this. It's a very original data I am giving you. So please take a note of it in your book and try to understand. So before, what was the composition? This is the current composition. This is NJAC composition. This is only called as collegium, means group of members who are involved in the selection of appointment of Supreme Court judges. This is also called as collegium. Some provisions are there in the NJAC. Let us see. We know that the Constitution has laid the method to appoint Chief Justice of India, Supreme Court and High Court judges. And Chief Justice of India, how he will be appointed, we already saw it. Now we are only concerned with these two people. The process, the people who are involved in the appointment of or selection of Supreme Court and High Court judges are, first of all, Chief Justice of India. Chief Justice of India, he should be there, the first person, and four other senior most Supreme Court judges. All of them, 1 plus 4 is how much? 5 members, including Chief Justice of India, can make recommendation for the persons to be appointed as a Supreme Court and High Court judge. So they will make recommendation to the President and President will appoint the same person. Their recommendations are obligatory in nature. Means when they give the recommendation, President has to follow the recommendation. That's why they are called as obligatory. Okay, means concurrence. It is also called as concurrence. Obligatory means concurrence. Okay, this is the 5-member body here. Okay, if you see all of them, everyone belongs to judiciary or not? Yes, Chief Justice of India judiciary, 4 other senior most judges judiciary. That's why I have written here, it is totally judiciary only, but it is both judiciary and executive. Now in the new NJAC bill, what is the composition by which appointment of Supreme Court and High Court judges will be taken up? Chief Justice of India कमीशन का था, कमीशन है ना, तो एक चेयरपर्सन रहना चाहिए. Chief Justice of India ऊपर बैठेंगे. Then 2 senior most judges of Supreme Court. यहाँ पे 4 थे, यहाँ पे 2 है. Right. Okay. So this part is judicial part. Then you are having 1 union law minister. Law minister, totally executive person, and you know that he will be governed by PM. Right? Of course. Then it means what? Executive is having a say in the appointment of what? In the appointment of judges of Supreme Court and High Court. Then we are having 2 eminent person. This eminent person can be influenced by the ruling party itself. They are nominated by PM, nominated by Prime Minister, Chief Justice of India, leader of opposition of Lok Sabha. Okay, remember this point, not Rajya Sabha. Rajya Sabha is not there. In NJAC, the leader of opposition could be from both Lok Sabha, Rajya Sabha. Means wrong. NJAC, the leader of opposition should be from Lok Sabha. If the leader of opposition is nothing but the party which has won maximum number of seats after the ruling party. The second party which has having highest number of seats. Okay, that is called as opposition. If not, any other party which is having what? Single largest party. Any other party in coalescence is also possible. Okay. So here we got how many? Supreme Court Chief Justice of India 1. Here 2 senior most judges of Supreme Court. 3 law minister is 4. Here 2 eminent person. 4, 5, 6. 6 are there here. Here how many members were there? 1 plus 4, 5 members. Here 6. Remember this point. And from this two eminent person, one person definitely have to be either from SCU appoint, STU appoint, or he should be from OBC or from minorities or from women. Any one you have to choose for sure. Okay, and one person could be anyone. One person could be anyone. This particular limitations are not there for another eminent person. Only one eminent person should be from this category. These two persons will be appointed for 3 years, and there won't be further reappointment. There won't be further reappointment. Remember this point. So have you understood now? It's a purely judicial, okay, in nature, but it is both judicial, executive, and non-political also. These two eminent person, non-political means they don't belong to political party. Normally experts you can understand, judicial, jurist, eminent jurist you can understand. They will be there. Okay. So it is having what? It is having multi, okay, multi-dimensional. It is multi-dimensional in nature, means it does not only include judicial one dimension, it includes executive another dimension, it includes eminent non-political persons also, okay, in the selection process. So this is the current system. This is the NJAC system. This system has been struck down by the Supreme Court. Supreme Court bole, no, we are not going to allow this particular system. Okay. So now this current system is only running. Fine. Then independence and validity. It has to be known to every one of you that if there is a vacancy is there or any defect in the appointment of any of the members with respect to the composition of the commission, no act or proceedings will be initiated. Okay, no act or proceedings should be initiated. Out of 6 members, if one member is not there, not present at the time of Supreme Court and High Court judges, it does not mean anything. It does not mean anything. Then you cannot say that ये पूरी composition पूरी fulfill नहीं हुई, 6 members were not there, but still Supreme Court and High Court judges were appointed. Okay, you cannot go to the court. It cannot be invalidated. It cannot be invalidated. So mere vacancy रहने के वजह से, mere defect in the composition of the commission, if it is there, okay, so the proceedings whatever happened will not be invalidated. Okay, then some other function, let us see what actually they do. The National Judicial Appointment Commission, some functions, let us see. They can recommend persons for the appointment of Chief Justice of India, judges of Supreme Court, Chief Justices of High Court, and other judges of High Court. Okay, appointment of all of them. Only appointment related aspects are there in A, 124BA. Recommend transfer of Chief Justice and other judges of High Court from one High Court to any other High Court is also done by them. Ensure that the person recommended is of ability and integrity. ये भी important criteria है. Is he able to become a judge of Supreme Court or High Court or not? Does he has been a person of integrity? So unka past record and all will be also seen, whether he discharged with utmost purity in their judgments or not. Okay, so these are the things that they do. So usually we can sum up that NJAC look after appointments and also transfers and appointments. That's all. If we just elaborate it, Parliament has given the powers to regulate the procedure for the appointment of Chief Justice of India and other judges of Supreme Court and Chief Justice and other judges of High Court. So Parliament may regulate, means this composition could be chota ya bada ya functions, all that could be altered. Could be altered, okay, by the Parliament by passing a appropriate law. Okay, this is all about it. Let us now see it. क्वेश्चन देखेंगे ना अपन, यही तो दिन यहीं पे आना है ना. NJAC is the outcome of 99th Constitutional Amendment Act. This is very true. That seeks to bring more transparency in the judicial appointment. The very important objective of NJAC is judiciary is only appointing the High Court and Supreme Court judges. It may happen that they will be bribed. it may happen that they may follow corrupt practices. Okay, and there is no accountability because they are only the justice system. They cannot judge themselves, right? Okay, they cannot sue themselves. So there is no accountability of them to the parliament. Okay, their appointments could not, their decisions could not be discussed in media and all. That will lead to contempt of court, and they cannot also question the wisdom of Supreme Court and High Court, and they cannot criticize them also. So it is a totally in-house process of judiciary, current process. So NJAC was built on the concept of trying to bring in transparency with respect to what? Judicial appointments. Means High Court, Supreme Court judges, Chief Justice, that kind of appointment, Supreme Court judge. Okay, so that is a basic concept. This is very, very true. NJAC seeks to modify the appointment process of judges only. This is wrong. NJAC, we have learned that it takes care of both appointment and transfer. Appointment and transfer. Only appointment is absolutely wrong. So ये wrong है. It envisages for the appointment of 7-member commission. 7-member is wrong. How many we have got? 6 members only. How many we have got? 6 members only. This NJAC, okay, NJA commission is a non-political commission. Absolutely wrong. It is a political commission because PM will be there. Union Law Minister is also there. Union Law Minister is also there. It's not a non-political commission. It is a political parties are also involved. The ruling party is also involved. The opposition party is also involved. So it is a political commission also. Okay. So the answer here is 1 and 3 are right. 1 and 3 are right. I guess you got this right. Little bit more information is there. Do we really have to revive this system? This is a question. Okay, why do we want non-political persons? Why do we want political involvement in the appointment of Supreme Court and High Court judges, Chief Justices, etc.? Why do we want it? Okay, political involvement. Let us see. The developed countries. Okay, there are some reforms committees and councils were there, law commissions were there that has given different compositions. Okay, they have recommended different compositions. At the end, we have got NJAC. It's not like that. We are not looking after the transparency in the judicial appointments. Lot of committees, commissions have given their reports with regard to the change in the composition of collegium system, the present collegium system which is followed by the judiciary in the appointment of Supreme Court and High Court justices and Chief Justices. Second Administrative Reform Commission in 2007, they have released a report. Okay, they told that from judiciary, Chief Justice of India should be there. Chief Justice of India should be definitely there. For High Court judges, Chief Justice of relevant High Court should be there. Okay, Chief Justice of relevant High Court judges. अगर हाई कोर्ट जजेस को अपॉइंट करना है तो चीफ जस्टिस ऑफ इंडिया रहना ही प्लस चीफ जस्टिस ऑफ रिलेवेंट हाई कोर्ट भी रहना है. एग्जीक्यूटिव से वाइस प्रेसिडेंट शुड बी द चेयरपर्सन, नॉट प्रेसिडेंट बिकॉज ही ओनली अपॉइंट्स. नो, वाइस प्रेसिडेंट शुड बी द चेयरपर्सन. एक पीएम शुड बी देयर, लॉ मिनिस्टर शुड बी देयर. अगर हाई कोर्ट जज है, ये पूरा सुप्रीम कोर्ट रहा तो चीफ जस्टिस ऑफ इंडिया. अगर एंड पीएम विल बी देयर. अगर हाई कोर्ट रहा तो Chief Justice of High Court and CM of State. So you can understand that this Administrative Reform Commission also recommended judicial plus executive composition. And from legislature, say Speaker of Lok Sabha, Leader of Opposition from both the houses of Parliament, and others no representative. Okay, this is the composition. Means judiciary is involved, executive is involved, and the legislative members like Speaker of Lok Sabha only. Okay, because Vice President is anyhow here, so he will be the chairman of Rajya Sabha. So he is like Vice President is anyhow there. So here Speaker of Lok Sabha, Leader of Opposition from both the houses of Parliament. So see, this is one. Okay, so you can go through 1, 2, 3 also. I will just again see this one, Law Commission, because you can just have a look over it. That is only my intention. Judiciary, CJI will be the chairman of this commission, appointment commission of judges. 3 senior most SC judges, means 4 member. immediate predecessor of CJI, means the moment this CJI will go, who will be the next one appointed on the basis of their age? He will be there. 3 senior most chief justices of high court. इतने हाई कोर्ट से अपने पास सबसे उम्र के the 3 high court judges which are having or which are oldest, उनको लेना है. ये जुडिशरी का कॉम्पोजिशन, जुडिशरी का कॉम्पोजिशन. ओके, फॉर हाई कोर्ट जजेस चीफ जस्टिस ऑफ रिलीवेंट हाई कोर्ट हमेशा लेना है. एग्जीक्यूटिव लॉ मिनिस्टर अटॉर्नी जनरल ऑफ इंडिया. ओके, लॉ मिनिस्टर अटॉर्नी जनरल ऑफ इंडिया. इफ दैट इज हाई कोर्ट जजेस सीएम ऑफ द स्टेट. लेजिस्लेचर में नो रिप्रेजेंटेशन, हियर लेजिस्लेचर में रिप्रेजेंटेशन था. अदर वन लॉ एकेडमिक मीन्स वन प्रोफेसर, वन डॉक्टरेट पर्सन, वन एमिनेंट जूरिस्ट को ले सकते हैं यहाँ पे. सो हैव यू अंडरस्टूड दैट वी आर ट्राइंग टू रिफॉर्म द appointment process of High Court and Supreme Court, Chief Justices and judges also. Okay, so this is some recommendations. None of the recommendations has been followed till now. Whatever the act we have got, that also has been struck down by the judiciary. Let us see other countries what kind of systems they are having. Let us see UK. Supreme Court judges are appointed by a 5-person selection commission. 5-person selection commission. It consists of Supreme Court President, his deputy, okay, one member each appointed by Joint Appointment Commission of England, Scotland, North Ireland, means political, because UK is very big country. They are having lot of sub countries you can say, or sub parts you can say, which are called as England, Scotland, Northern Ireland. It means political representation, regional representation is given here. Regional representation is given here. Okay, the JAC, whatever the one member each appointed by JAC. The JAC comprises by lay persons, members of judiciary, bar members. Okay, make appointments of judiciary of lower courts. You can see, you can go through all of them. No need to study, no need to buy hard any of this. I am just trying to give you that unke can say compositions hai. Okay, let us see this USA. America का देखेंगे. Appointments are made by president. President like Joe Biden can directly appoint the judges, but they have to be ratified by what? US Parliament, which is called as Senate, US Parliament. Okay, ratification hona, confirmation should be given by them. Okay, very simple process, one and go. France में, okay, this is not required. Again, I have to tell you what is this, the meaning of this French word. That is not important. Okay, you can go through all of this. Okay, just have a look that India को छोड़ के how other countries, developed countries, follow the appointment of judges of Supreme Court and Chief Justice of India. Then the second question, which among the following are the qualifications required for the appointment of Supreme Court judge? Supreme Court judge. Now let us see the data. A person shall not be qualified for appointment as a judge. Okay, unless means you just not, and unless is nothing but you minus plus only, means these should be there. These should be there. A person is qualified for the appointment as a judge of Supreme Court if he is a citizen of India. And you see here and is written, means citizen of India is compulsory, plus either he could be distinguished jurist, or he could be a high court judge for 5 years, again, or has been an advocate of high court for 10 years. Means this combination is okay, this combination is okay, this combination is also okay, because it is or. One thing is very common here, he should be citizen of India. So he should be citizen of India, citizen of India, citizen of India, citizen of India. So very right. First of all, we have seen that citizen of India is important or not. It means the moment we see here, okay, this option is gone. Why? Because this option does not take into consideration what? Citizen of India. Okay, let us go ahead. Distinguished jurist, yes. High court judge for 5 years at least, yes. Advocate of high court at least for 10 years, yes. Citizen of India is there, yes. Citizen of India is there, yes. Citizen of India is there, yes. Okay, we are having no? Right, all are right. Citizen of India, high court judge for at least 5 years, distinguished jurist. No. This is not at all there. These three combinations are only right for the appointment of judges of Supreme Court. So answer here is 1, 2, 3. Okay, this either it should be disqualification, either he should be disqualification or disqualification. Any of them could be appointed. It's not and, it's or. Remember this point. Now the next one. Consider the following statements. A person who is in the age of 22 years could be appointed as a Supreme Court judge. Judge of Supreme Court and High Court does not enjoy security of fixed period. Supreme Court or High Court judge vacancies exist only on two grounds, either from the resignation or from the motion passed for impeachment. Okay, motion passed for impeachment. Here, if you see, a person who is in the age group of 22 years could be appointed as a Supreme Court judge. Very, very right. Because for the appointment of Supreme Court or High Court judges or Chief Justices, there is no minimum age. There is no minimum age. Just education qualifications are there. That is not important. We are talking about age here. So no minimum age. Anybody could be of any age having the requisite education qualifications would be appointed. So this is right. Okay, incorrect statement he is saying, but this is right. Judges of Supreme Court and High Court does not enjoy a security of fixed period. Yes, 5 years they will be appointed or 6 years they will be appointed. It will not be like that. It will not be like that. Suppose my age is 61. Supreme Court judge retirement age is 65. I may get only 4 years, 5 years to serve. Your age is 63. Supreme Court retirement age, judge of retirement age is 65. So you may get 2 years. That's why there is no security of fixed period. Okay, anybody can get any of the period. किसी को 30 days हो सकता, 6 months हो सकता, whatever it is. There is no security of fixed period नहीं होता. Whatever is left with regard to your upper age limit, that will be your security of age. And Supreme Court and High Court judges vacancies exist not only on two grounds. These two grounds are anyhow there. It is actually on three grounds. Or a cat death. Or a cat death. Remember this point. So resignation is one. Motion of removal is second. Death is also there. Third. So this is also wrong. Only which one is right? Okay. Find the incorrect. Find the incorrect. So we are having this only three is incorrect. Right or wrong? Because judges of Supreme Court and High Court does not enjoy security of fixed period. That is also right. A person who is in the age group of 22 years could be appointed as a judge of Supreme Court. That is also right. That's why the incorrect option is only 3. This is wrong. Because not two grounds are there. One more ground is there, that is called as death. अब देखेंगे. No minimum age. So it means अपना ये statement right है. This statement is right. Okay. Nor any fixed period of office. Very good. Nor any fixed period of office. That is also right. Okay. Once appointed, a judge of the Supreme Court may cease to be on the happening of any of the following contingencies. Death है. Okay, ये तो है ही है. Death में he ceased to be a Supreme Court judge. Death, resignation, and motion passed by the Parliament of his removal. Okay, I think you got it. Consider the following statements. All judgments and laws declared by the Supreme Court are binding on all courts of India. Very right. I have written here all. If you hear only Supreme Court, don't get confused. All high courts, all subordinate courts, like civil courts, criminal courts, kitne bhi courts ho, it's okay. Supreme Court acts as a court of appeal, right? As a federal court, solve disputes of the units of administration, right? He is a guardian of constitution, right? Any provisions in violation of our constitution will be declared void by the judiciary or not? Yes. So he is guarding the constitution, protecting the constitution from the tyranny of the ruling party or not? Yes. Executive or not? Yes. Okay. ये देखो ये थोड़ा बहुत it is little bit difficult. Why? Because you know in the mains examination you are having India's constitution in comparison to many countries like that you are having. So one of the main point I have given you, because USA is a big country, you should know how they do it. Supreme Court of India has more powers than American Federal Court, because Supreme Court does not only solve federal disputes, okay, like American Federal Court, but Supreme Court also consider appeals of lower courts in all matters. In all matters. Remember this point. हमारे अमेरिका में, our America is there, no? In America, a federal court is there. ओके, दैट्स ऑल द डिस्प्यूट्स ऑफ न्यूयॉर्क बिटवीन मिशिगन वॉशिंगटन, इन दोनों के डिस्प्यूट सॉल्व करते हैं। ओके, and every state of US has got its own high court. High court will take care of, high court will be the highest appeal of that particular place. उसके above they cannot go to federal court, they cannot go to federal court. So जैसे कि अब इंडिया में तेलंगाना का हाई कोर्ट है, Telangana High Court we are having. Telangana High Court has given any judgment within our state. If I don't like it, I can go to Supreme Court. But it's not in case of America. In case of America, the federal, the every state has got their own court. The moment the court decide, that is final. The America also have got a Supreme Court in the form of what? Federal court. But this federal court performs only one function. What is that? To solve the dispute between the American state. But हमारा Supreme Court not only it solve the dispute between the तेलंगाना या आंध्र प्रदेश का कुछ प्रॉब्लम है, यूपी बिहार का कुछ, नॉट ओनली यूनियन गवर्नमेंट का इनसे प्रॉब्लम है, it not only solve the disputes of federal units but also it hears the appeal of high courts also. High courts also. This provision is not there with the federal court. Okay. So all the three are right, my dear madam and sir. All the three are right. Right. Here let us see. The law declared by Supreme Court is binding on all other courts within the territory of India. In very small examination, small category examination, they will ask you this article. Which one of the article binds all high courts, okay, to follow the Supreme Court judgment? Article 141. Article 141. Remember this point. इस हिसाब से अपना first statement is right. Second statement, American Supreme Court appellate jurisdiction is confirmed to the cases of federal units only. That is what I have told. Federal units only. But our Supreme Court is not only a federal court, but it is a guardian of constitution, highest court of appeal in the land, relating to civil and criminal cases, apart from cases related to interpretation of constitution. So the Supreme Court role in India is wider than the federal court role in America. Federal court role in America. Okay. Supreme Court of India enjoys extraordinary power to entertain, to admit the appeal from the decisions not only from any court of our country but also from any tribunal within the territory of India. That is what I have told you. That is what I have told you. Okay. So with this, this is also right. तो ये तो आपको पता ही है. So that's why all the three are right. Now the last one we are having. Consider the following statements regarding the original jurisdiction of Supreme Court. Supreme Court can suo motu itself transfer the cases pending before High Court or any other courts and dispose of justice by itself. If a case is being appealed in a particular High Court में तेलंगाना High Court में एक केस डाले, अगर Supreme Court felt that okay it should be decided by me, मैं decide करना ये, Supreme Court can ask the High Court भेज दो वो केस, आज से मैं देखूंगा. This Supreme Court can do this suo motu, खुद का खुद कर सकते. It's not like that somebody should appeal to the Supreme Court, please whatever the case is there in High Court, sir you please take this court. It's not important. कोई अपील करने की जरूरत नहीं है. Supreme Court on its own can ask a High Court, please you don't do it, we will give the justice by ourselves. This is also possible. Supreme Court can transfer the cases from High Court of one state to High Court of other state. तेलंगाना हाई कोर्ट से लेके आंध्र प्रदेश हाई कोर्ट को भी दे सकते. This is also possible. Just like कंगना का हो रहा था, मुंबई हाई कोर्ट was taking care of. So बिहार हाई कोर्ट में डाले तो वहां पे शिफ्ट करो केस, वहां पे शिफ्ट करो केस, या उत्तराखंड में शिफ्ट करो केस. Like that they are saying, like she is from Himachal Pradesh, no, like that. So Supreme Court can do this suo motu. Supreme Court can do this suo motu. Whether these two powers of Supreme Court belongs to its original jurisdiction, means no other can have this much powers. They have the original powers on it. Is it so? Okay, let us see. Constitution of India provides that when cases involving some questions of law pending before the Supreme Court and one or more high courts one or more before any or the high courts. Okay, if the Supreme Court is satisfied on its own or any application made by Attorney General or by any party, it means मैं पूछ रहा हूँ Supreme Court आप वो case ले लो, then Supreme Court may withdraw the case pending before the High Court and dispose all of the cases by itself. कर सकते, yes, very true. First statement is very true. Okay, अगर सुप्रीम कोर्ट सेटिस्फाई हुई, खुद से ही सेटिस्फाई हुई, या अटॉर्नी जनरल लिखेगी आप हाई कोर्ट वो जो इलाहाबाद हाई कोर्ट जो केस कर रहे आप ले लो वो कोर्ट केस और आप डिस्पोज करो, और एनी अग्रीव्ड पार्टी टू दैट पर्टिकुलर केस दे से दैट सर आप देखो केस, तो सुप्रीम कोर्ट कैन on the merit of the case, if Supreme Court is satisfied that a substantial interpretation is there with regard to constitution or any law में एक factual error है, so Supreme Court will say दे दो, so that is right. अगर सुप्रीम कोर्ट को if any high court के पास एक केस है but that case have to be solved expeditiously, जल्दी जल्दी केस को सॉल्व करना है, but high court because of political pressure is doing delay, in this case also Supreme Court बोलते भाई आप मत करो, you don't do it, we'll do it. Okay, see, if it is important to expedient or to give the justice speedily, okay, Supreme Court may transfer any case or any appeal, any other proceedings pending before any high court or any other high court. Supreme Court बोलते हैं हम कर लेते, आप डिले कर रहे हैं ना, आपसे नहीं हो रहा, give us. If it is a matter of importance, Supreme Court can do this also. And the last one, this was not given by me to you in the statement, but I have told you to study because आपको कुछ सीखना बोल के बोल दिया भाई. Then another provision is transfer. Supreme Court may transfer any complaint. Suit means complaint. Suit means charges against any individual. I will see you means I will put charges on you and I will see you in the court, like that they will say, you know, like that. Supreme Court may transfer any suit, any appeal or any running proceedings, already case चल रहा है, from a high court or any other court in one state to high court or any other civil courts in other state, कर सकते. This is also I have given you. Supreme Court can transfer the cases from High Court of one state to High Court of other state, or civil cases कुछ भी रहो, it can do. It means what? Both the statement are true. The access information is there on the slides, on the images. You can go through it. If you have any doubt, please do ask me. Thank you so much for hearing to me. Do subscribe to my channel and also join my Telegram group. Okay, I'll give you more 5 questions, 11 to 20 questions I will give you this time. Okay, so that is like more detail we will do. Go ahead, and I know that with the kind of phase we are going, so you are going to be very perfect in your polity, economy, environment, whatever I take up. But polity and economy will take first because they are the ones which are going to give you 40 marks in UPSC. 40 marks in UPSC means almost around 80, 40 questions means almost around 80 marks. The cutoff is only below 100. So the moment if you are very perfect in polity and economy, all my students who are in the group will be very happy and they will be through. I will be most happiest person if that happens. Please don't give up, study well, don't quit UPSC, it's your life, and okay, don't just try to be lenient on UPSC also. जिंदगी में कुछ करना है तो you have to work out. Bye bye, take care. Happy Eid once again.